Hello, everybody, and welcome to this edition of Macro Pro and Friends. Today, I'm joined by Jim and Logan. How are the two of you?
Hi, Diane. I'm good. How are you?
I'm excellent. Thank you very much. Jim, you're good?
I am. I'm very good. I'm happy to be here.
Yeah. So, Logan, what is new and exciting?
No, since we've last chatted, nothing much. I did get a new puppy. My boyfriend and I just got a puppy. He's in the other room, asleep, finally.
It's like a baby. What type of dog is it?
He's a Cavapoo, and he's just 4 months old. So it's been fun, a little crazy, but it's been good.
Oh, very nice. Now, speaking
Yeah.
of dogs, Jim, you have quite the story during the pandemic about dogs. Can you share that with us?
Absolutely. During the pandemic, my wife and I elected to foster dogs and rehab them for families. We work with a foster agency that's trying to get the dogs out there. And we've had a number of dogs through our house, which were easily adopted during the pandemic. And the most recent one, though, he was a little bit more traumatized before he got to us. So it took a little bit more rehab. And just Monday, we found a forever home for him.
Oh, so fantastic. I love that. My husband and I did a lot of work when we were in Sacramento. We had our own charity called Have a Heart, and it was to bring children to forever homes adoptions. So whether it's two-legged or four-legged, we love to see a happy ending where everybody ends up in a home forever. So
Yeah.
very nice work, Jim. Great job. Excellent. Well, before we get started with today's presentation, I have a little bit of housekeeping to do. So today's presentation is worth 1 hour California CEU credits, and you must be logged on to the GoToWebinar platform. So that means you use the link, you click onto it. That way GoToWebinar can track your time and attendance. If you're just calling in, unfortunately, they can't do that. Now, if you have questions for Jim for today's presentation, and it's avoiding litigation potholes, which is just a huge topic, and I'm sure you have lots of questions for Jim, please make sure that you put them into the question box or the chat box, and we will be monitoring those. Now, I should say, if we don't get to your questions, we will make sure that Jim gets a copy of the questions so that he can address them to you at a later time. So please don't fret if your question isn't being answered. And then there are handouts for today's presentation. So please make sure you download them now so that you have them for future reference. And then lastly, there will be an encore presentation of this program on the Macro Pro YouTube channel. So be sure to look for that. So Logan, I'm going to turn this over to you now so you can introduce Jim, talk a little bit about your firm, and we'll see the rest of you in about an hour.
Awesome. Hi, you guys. My name is Logan Schlossberg, if you have not met me already. And Jim and I are coming from Schlossberg and Umholtz. Jim is down in the Brea office. I'm up in Los Angeles, and we're so happy to be here. Thank you guys for all coming today. Our topic is one of the biggest, it's a fan favorite right now for this year, avoiding litigation potholes. Like Diane mentioned, it is a pretty large topic. So yeah, feel free to put your questions in the box. We'll try to get to them. And if not, we will get that list and get back to you on whatever question you had. So that's it from me, and enjoy the presentation. I will turn it over to Jim. Thank you, guys.
Good morning, everybody. My name is Jim Umhotz, and it's always a pleasure to work with Macro Pro on putting together these little training seminars. I really strongly encourage you to provide questions. It's the questions that put together each of my presentations, and it's questions that give me the information to feed back to you. The nicest thing about my job is I tell you a lot of the things that you already know, and that's what I'll do today. But hopefully after today's presentation, I will have put maybe a sharper point on the pencil, a little bit more detail into the information. Now, today's presentation I call Avoiding Litigation Potholes. Now, I do that as more of a catch-all program. I do that because this program has changed since it originally started. I take information that's provided to me, I take issues that are presented to me, and I try and turn them around into training material to help you avoid these problems in the future. That's where I come up with the Avoiding Litigation Potholes. I have my usual disclaimer on page 3. But the first thing I want to strongly emphasize to you is that you document your file. People say, Jim, you've been doing this for years. You keep saying this, but I will tell you from the attorney's perspective, we live and die by that documentation. It's the documentation that makes the file. Now I'm going to give you 2 reasons why documenting your file is very important. Reason number 1 is that the claims examiner who is handling this file after the claims examiner who replaced you doesn't know what you were thinking when you made decisions. They simply don't know. So unless you document what you did and why you did it, nobody in the future will ever know that. And to defend these claims, we need that documentation. Even if the documentation isn't perfect, I can defend it. But if the documentation isn't there, that is almost per se a penalty. Second reason, by the way, is that the board has an extremely liberal bent towards the injured worker, towards the applicant. It's even codified in Labor Code Section 3202, where they have to interpret the law liberally in favor of the injured workers. If we are to overcome that, we need evidence, and that evidence usually takes the form of documentation. Now, I've had employers and some claims professionals tell me that simply documenting things, they're worried that putting down the wrong thing will hurt them in the future. Well, I promise you that putting down nothing will hurt you more. You need to put some documentation in your files if you are to succeed at later dates. Now, the most common type of documentation are benefit notice letters. Now you say, Jim, I know about benefit notice letters. Why are you talking about them? Because this is a very common source of problems in files, and it's also a common source of audit penalties. We need these records to be accurate, and we need these benefit notice letters to be complete. They need to be in plain language. I'm not going to go over the letters in detail here, but I am going to highlight the website listed on page 5 because they provide you with a benefit notice manual that tells you everything you need to put into the benefit notice letters. But to briefly summarize that, anytime you start, stop, delay, change, terminate, resume any type of benefit, you need to send a benefit notice letter. If you are delaying temporary disability, benefit notice letter. If you're stopping temporary disability, benefit notice letter. And when you stop those benefits, you need to put certain attachments along with the benefit notice letter. The most common attachment is a benefits printout, a record of payment of the benefit that was paid and addressed in that letter. So if you're sending out your final TD notice, you need to attach your printout of temporary disability benefits so the injured worker can look at that. Now keep in mind, benefit notices must issue with the first or last payment of any benefit, but no later than 14 days from the date the decision was made. That's an important distinction, that 14 days. Oftentimes people will come to me and say, Jim, we've denied this claim. We're now choosing to accept it. Do we have to pay penalties on the benefits that have accrued? The answer is, if initial payment issues within 14 days of our decision to accept the claim, no penalties are owed. I'll say that again. If the decision is made within 14 days of, if the payment is made within 14 days of our decision to accept liability, no penalty is owed. So keep that in mind. We need to make those decisions. We need to document when the decision was made. And if payment is warranted, send the payment out within 14 days. Now let's talk a little bit about overpaid benefits. Oftentimes, or mistakenly, we will overpay temporary disability. Now, we maintain the position that you can convert a benefit from one type to another under certain conditions. And I'm going to emphasize that it's under the certain conditions. So for example, I have never had a judge tell me I could not convert overpayment of temporary disability to permanent disability as long as, number one, we acknowledge that the permanent disability payment is owed. And how do we do that? With a benefit notice letter. And two, we only convert the new rate. So for example, temporary disability is payable up to $1,200 a week, but permanent disability is only payable at $290 a week. If for some reason we overpay temporary disability, we can convert $290 a week from temporary disability to permanent disability. We can do that without issuing a petition for credit because we're not asserting credit. We are simply converting from one type benefit to another. I have never had a judge tell me that is wrong. I have never been penalized for that. So just remember, if we delay PD, we cannot do this. And we cannot convert the entire amount of the temporary disability payment per week. We can only convert the PD rate. So keep that in mind. But if you have a credit otherwise, there are rules for petitions for credit. The first rule is a petition must be filed. If we have overpaid temporary disability and we want credit for that overpayment, we must file a petition. And what you need to understand about those petitions is those petitions are purely within the discretion of the judge. The judge gets to decide whether the credit is granted or not. And I will give you some very quick overviews. If the credit occurred because of defendant's mistake, in other words, if we paid at a rate that was too high for temporary disability, or if we paid beyond the 104-week limitation of temporary disability, the judge will routinely deny that. I've never seen a judge grant a credit for temporary disability paid beyond 104 weeks. Likewise, if the credit is a result of employee misconduct, if the employee was collecting EDD benefits while collecting temporary disability or working while collecting temporary disability, the judge is generally prone to grant that credit. But there are a lot of situations which occur which don't involve either defendant error or employee misconduct. And you'll see I've given you several cases. And anybody who has heard me speak before knows that I give you these cases as a reference point. I'm trying to highlight certain issues, and I encourage you to read through these cases. And when you do, I encourage you to decide whether these meet your fact profiles. Because if they meet your fact profile, I encourage you to read the entire case and decide whether this case is on point and whether you can assert this case. But if you look at like the Asher case, they said that the period between the examination, in this case an AME exam, and receiving the report where applicant received temporary disability benefits, credit was denied. So we have an AME exam, 60 days goes by before we get the report, and we continued paying benefits during that 60 days. The judge denied this. And you will see in several other of these cases that when the applicant is unaware that the physician found them to be permanent and stationary, they have denied defendants credit. You will also see that where the physician found a retroactive permanent and stationary date, in other words, the exam occurred maybe in July, and the doctor says, oh no, they were permanent and stationary back in February. With those retroactive application of permanent and stationary or MMI status, the judges will tend to deny the petition for credit. We want to keep that in mind because they will also deny the petition for credit if defendant failed to object to temporary disability during the course of the claim. So keep that in mind. Did we object? Look down to the Johnson case on page 9 towards the bottom. Defendant never objected to ongoing TD. Therefore, the payments were made in good faith. If we made temporary disability payments in good faith, the judge won't grant credit. And that's what more of these cases say as we move from page to page. But what I chose to do here is give you on page 12 some criteria to look for. So let's ask ourselves, did defendant ever object to temporary disability? I say object early and object often. If somebody is requesting a QME, object to temporary disability. You can object via letter, by a benefit notice letter, and still continue to pay benefits. You don't have to cut off benefits and object. You're objecting to the ongoing TD. Next, was the P&S report served on the applicant? Because applicant's knowledge impacts defendant's credit. Now, here's a litigation point. Here's for those of you who've got your pens and papers out, you might want to write this one down because I didn't include it here on the page. When you know an exam is going forward, a QME or an AME exam, call the doctor the next day. Call the doctor and ask, did the applicant attend the exam? And if yes, is the applicant MMI? If they tell you it's too soon to tell, you can delay further temporary disability until you get the report. Now remember, when you get the report, if the report indicates they are not MMI and there's evidence that they are temporarily disabled, you have 14 days to pay during that period. But when you know the exam goes forward, check with the doctor, document your file, and send out a temporary disability delay letter because we don't have the information as to whether or not they're permanent and stationary. It's a little bit more difficult if the P&S report shows a retroactive date, but even if it did, we want to make sure that we had objected to the temporary disability throughout that retroactive period. Object early, object often. And was the temporary disability paid in good faith? If we are not objecting to it, it is likely paid in good faith. Now, I'll give you the caveat that no judge I've known has ever skipped over, and that is, will the credit eliminate permanent disability payments? If we acknowledge that $5,000 in permanent disability is payable and $20,000 is a TD overpayment, it's unlikely they're going to grant that payment. But we could still ask for it. We don't know the facts. If it were a result of employee misconduct, the judge may grant it. So make sure you file that petition for credit. By the way, while we're going over fine points or litigation points, when you send out any benefit notice letter, I say from the very first TD letter, from the first delay letter, from the denial, you want to include on that letter Reynolds language. Now, for those of you who haven't been in the industry for 30 years, Reynolds was a case some years ago that says that if we don't tell the employee that they have a limited time frame to file an application for adjudication of claim, we waive the statute of limitations. I'll say that again. If we don't tell the employee that they have a limited time to file with the WCAB, we, the defendant, waive the statute of limitations. So it's always good to include in every benefit notice letter language saying, if you do not file an application within either 1 or 5 years, depending on whether it's a denied claim, that they will lose their right to do so. Reynolds language, write that down. Litigation point, keep that one in mind. Let's move forward. Not all issues are dependent upon a benefit notice letter. For example, you will oftentimes get requests for out-of-pocket expense reimbursement, mileage requests for consults that aren't covered within utilization review. And I'll talk more about treatment authorization requests in just a moment. But any demand you get in, you need to respond to. This is part of that documentation we were talking about. You will hear at applicant attorney conventions, you will hear at their local meetings that they're baiting us by sending us multiple demands in an effort to get us not to respond, because our failure to respond may be deemed a denial of medical treatment, and we will lose control. We will lose medical control. We will lose medical provider network or MPN control. So anytime you get any demand in for type of treatment or benefits, make sure that you respond to it, even if it's only to say, Mr. Applicant Attorney, this claim is denied, therefore we're not reimbursing out-of-pocket expenses at this time. We're not reimbursing mileage at this time. Make sure if it comes into you, it's a trap. Make sure you respond to it so you don't fall into that trap. Now, as I mentioned before, a lot of issues pop up or in my own practice that lead me to raise issues here in my presentation. And one of the more recent ones has been that applicant attorneys have been demanding maximum temporary disability rates in death cases, even if the employee's temporary disability rate is substantially below maximum. I'll say that again. They will demand maximum temporary disability, death benefit rates, even if the employee's wages warrant a lower rate. So what am I talking about? As I said, maximum temporary disability is about $1,200. And if the employee's wages warrant only a $400 a week payment for death benefits, they'll demand the $1,200. And if you look on the next page, there's a whole series of cases that support this. What I want you to look at, though, with these cases is not the facts in the case, but rather the dates. You'll see that the Aguirre Farias came in 2002, Foodmaker in 95, Price Mercantile in 57. There's a 92 case and another 2002 case. And all of these cases predated the rule that says that minor children receive benefits until they become 18, and disabled children get benefits for the rest of their life. So you can see where that might have a greater impact. Generally speaking, death benefits are paid to an amount certain, depending on the number of dependents. But if you increase the rates and you have a child under the age of 18, that $320,000 maximum benefit can be increased tremendously, possibly up to $500,000 or more. So be aware that these demands are being made. Be aware that the case law that supports them predates the changes in the law. And I have successfully argued that this case law does not apply to modern cases. Therefore, we don't have to pay at an increased rate, or I will solicit an agreement with the applicant attorney that we're still only paying to the maximum death benefit rate. Now, this issue here applies to death benefits only, but when you see this issue come up, make sure you're aware that the cases they rely upon are all old. Now, I put on this page 16, let CAW be your guide. For those of you who don't know, CAW is the California Applicant Attorneys Association. And that's a group that gets together several times a year, and they get together more often in their local environments to talk about ways to take more money out of our pocket. And I've given you examples of things that they talk about, like expanding employment, strategies to beat utilization review. And I'm going to talk a little bit about some of these as we go forward, but understand that they spend a great deal of time looking for ways to circumvent the rules or to use the rules to their advantage. My purpose today is to try and convince you to use the rules to our advantage. For example, there has been a big issue with employment and employer. Now, with traditional employment, someone working for another person, identifying the employer is very easy. But in this modern world, we have other issues. We have temporary employees. We have leased or contract employees. We have subcontractors. We have professional employers organizations. We have general and special employment relationships. So what am I talking about? Well, the claim that I'm handling has my client, who is the end employer, who would be called the special employer. They actually got an employee through a temporary agency, and they hire all of their employees through this temporary agency for the first 90 days to see if they work out. That temporary agency paid for the employee through a professional employers organization, a PEO. So the money that goes to the employee came through the PEO, through the temp agency, for work done at my employer. And that PEO had insurance that went out of business. Now, don't worry about the going out of business part. That's a whole different discussion. But the point is, we need to clearly identify who our employer is, who we are representing, and how we wish to defend that. We may want to push liability on one employer or another employer, maybe the PEO pushing on the temporary agency pushing back on the PEO. But remember, when defendants fight, applicants win. I'll say that again. When defendants fight, applicants win. Think about a cumulative trauma claim where you have two separate carriers providing coverage, and each carrier gets a report saying that the other carrier is liable for that injury. Now the applicant has two reports saying that the employer is liable, and we have no report saying we're not liable for that injury. Yes, we do have issues between who has to pay, but these can be fought later. We don't want to be fighting with each other as employers, at least while the applicant's still in the game. So make sure you communicate with your co-defendants and try and get the applicant out of the picture before we end up fighting with each other over employment or who's the proper employer. That's not always the best situation, but remember, when defendants fight, applicants win. Let's talk about medical provider networks. They only work if we use them. In other words, we have a limited period of control, which can be forever, but we have to act to do that. So what I do in my practice is I keep a list of my clients' websites, MPN websites, readily available on my computer. So if an applicant attorney makes a demand on me for that website, I can send it to them literally within minutes, assuming I'm sitting at my desk, but I can send it to them right away. I encourage you to do the same thing. I don't care if they ask you 3 times in a week or 3 times in the same day. There's a reason they're asking over and over again. That reason is to bait you. What I'm encouraging you to do is have it readily available so that you can send it to them again and again and again. Caveat, make sure the website works. Recently, I had a client who on their benefit notice letters listed an MPN website that they no longer used. And they didn't realize it was on their benefit notice letters because the letters weren't updated since they updated their MPN. So make sure the website is good, but make sure it's available to you to send out to the employee or the applicant attorney right away. Don't delay. Don't give them a reason to say we're not providing services. Likewise, whether the injury is admitted or delayed, schedule that initial MPN exam. In fact, I will give you a practice tip. For every time the applicant elects a doctor within the MPN, every time he changes doctor and elects a doctor within the MPN, schedule that first examination. And I'm going to tell you why. I see a lot of applicant attorneys calling me up and saying, you need to send authorization, you need to send information, you need to send all of this to the MPN doctor or they won't examine my patient. Then I turn back to you and I call you and I say, yeah, we should do this. The problem, however, is that we don't know that they ever called the MPN doctor. We don't know that they ever tried to schedule that exam. They just try to put a burden upon us, to shift burden onto us so it looks like we're not doing anything. If you schedule that exam, the first exam with every elected physician, you know what that doctor wants. If they want a written authorization, you could send it to them. If they want medical reports, you could send it to them. You can ask me to send it to them. But we know what they want and we know that exam schedule. Second reason to do it is because on more than one occasion, I have had my clients, or excuse me, I've had them, my applicants elect a doctor and never go to that doctor. They elect it on paper, but they never go. They continue going to their existing doctor. Now, I will tell you that the board, the WCAB, does not like benign neglect. In other words, if we allow them to continue treating with a non-MPN doctor despite their election, the board is going to recognize that doctor as the primary treating physician. They're going to say later that, hey, we could never get an appointment with that MPN doctor. Well, if we schedule that appointment, they can't say that. Now, I've had some claims professionals say to me, Jim, I don't know when the applicant's available. Well, if they're on temporary disability, they're available every day, all day. It doesn't matter. If the doctor's scheduling at 7 in the morning, that sounds like a good time for me. So schedule the exams. Now, with either admitted or delayed claims with that initial MPN exam, I put on my presentation here, it does not matter if the employee attends. Why am I saying this? If we schedule the exam on a delayed case and they fail to go, we have a strong argument that they're denying us our medical control and we can reject any medical reports they solicit outside our medical control. If we don't schedule that exam, they can say that we didn't schedule it and therefore they can go to the doctor of their choosing, regardless of whether we provided them proper notices, regardless of whether we provided them the website. So it's to our advantage to schedule that initial MPN exam, even on delayed claims. By the way, if they go, at least we have a medical opinion from a doctor that we recognize, and we can evaluate their complaints based on that. I also put on page 18, provide written authorization when it's requested by applicant attorney or by the doctor. Give them authorization to treat, but I strongly recommend against discussing body parts. Why do I say that? I am not a doctor. I don't know who's listening out there, but I'm sure you're not a doctor. So when an applicant goes to the doctor and says, we acknowledge that they stubbed their toe, but they're claiming shoulder and neck problems, let the doctor explain how the shoulder and neck are related to that stubbed toe. We could say they're not, but we're not doctors. It is the applicant's job to report the parts of body that they claim pain, and the doctor's job to tell us how they relate. So if you want to describe the injury to the doctor, applicant stubbed his left toe, or his left big toe, on a chair as he was walking through the room. He'll describe the body parts. Do that. If we deny body parts, that immediately opens the door for a medical legal examination, and that's a way that applicant attorneys bait us into getting more medical legal examinations, is they include body parts and expect us to deny those body parts. Now, I'm sure somebody's out there saying, but Jim, if they stub their toe, we acknowledge that, and they list the neck and shoulders, what do we do when they get a request for treatment for those neck or shoulders? Well, my answer is ask the doctor how the neck and shoulders are involved in this claim. Title 8, Section 9785 requires the doctor to give us reasonable information upon request. And if the person has never claimed these body parts to the doctor, has never reported symptoms to these body parts, the doctor should be able to explain why now they need this treatment. And you could tell the doctor, I have 14 days to respond. Remember, we have to get our utilization review done within 14 days. Doctor, I have 14 days to respond. How is the neck and shoulders related to this stub toe? Failure to update me will result in denial of this treatment and possibly a delay in benefits. It is the doctor's job to tell us what the problems are, not our job to tell the doctor what the body parts are. Let's keep going. Regarding treatment, applicants will claim they have a pre-designated physician. Well, if you don't have the paperwork for that, then it doesn't exist. They will request written authorization for treatment over and over and over again. That's what they do. They request authorization for treatment, hoping that we will ignore them. They will request that we identify admitted body parts. Remember, denied body parts get treatment outside the MPN and open the door for a medical legal exam. Obviously, they'll request changes of treating physicians. They'll request our link to the MPN. They'll request that we schedule an exam. I support all of these. Give them the link, schedule the exam, make sure they're getting the treatment. Do not give them an outlet to say that we are denying medical treatment. The only way we fail in any of these is if we fail to respond and fail to document our file as to our response. Now let's take a little bit of a side trip here. We've been talking about notices, we've been talking about documentation. Let's talk about the new psychiatric injuries. We all know that the labor code was amended to say that permanent disability is not payable if the psychiatric injury is a compensable consequence of a physical injury. So how has the applicant bar responded? Well, there's a lot of claims for traumatic brain injuries now, even from minor incidents. There's claims for post-traumatic stress disorder. I was talking today about a conversion disorder where a relatively minor claim has resulted in rather significant impairment, resulting in the employee being determined 100% permanently disabled. Now, what do all of these conditions have in common? Well, number one, there is not a definitive diagnostic test that can demonstrate traumatic brain injury or conversion disorder or post-traumatic stress disorder. Each of these conditions is diagnosed based upon behavior. And that's where we get to the neuropsych evaluations. Neuropsych evaluations. You'll see on the next page that I talk about neuropsychology, but what they're trying to do is link behavior to brain disorders. Now, from an analytical concept, it's great. If we can link the brain activity to behaviors, we have a great tool. but this is not a great tool for determining causation. For example, if somebody has impaired cognition, they have impaired concentration or poor coordination of their words, how do we know that this is a result of an injury, number one, and our injury, number two? So for example, with each of these conditions, if they request neuropsychiatric testing, that testing looks at their capacity today. It does not evaluate their capacity pre-injury or pre-employment. So how do we know that somebody who is working in a minimum wage, low demand job didn't have impaired reasoning or memory prior to having that job? There's a reason that they are working at a minimum wage job with a minimum demands on them. There's a reason that people with limited abilities take these type of jobs, but we have no way to determine this. So if we're dealing with a neuropsychology-based examination or with other types of these physically based, emotionally related injuries, we have to look at the behavior. Behavior during the jobs, behavior prior to their job, and behavior after the injury. Now, this is not an easy thing to do. This may involve going back and getting school records. This may involve confronting the doctor with applicants' lack of activity prior to the injury, prior to their employment. But be aware that neuropsychology testing is on the rise, and it's horribly, horribly expensive. Every neuropsychologist wants to be treated as a med legal. They want to get $3 per page for reviewing records. And the ones that I have seen cross my desk usually want between 16 and 25 hours of testing over multiple days. And they bill us for all of that. And in the end, all they can tell you is whether this person's behavioral changes may relate to some organic brain issue, but they can't tell you whether it actually is a result of our injury, is a result of any injury. It may be the result of genetic issues or some other neurological or medical issue. Be aware, this is the new psychiatric claim because there are no diagnostic tests which clearly delineate these conditions, and they're based on behavior, and behavior can be controlled by the injured worker. By the way, there's a whole bunch of groups that certify neuropsychologists. I've given you a list on page 22. If you're getting testing, make sure that it's done by a doctor within at least one of these groups, if not more than one of these groups. There's really, any psychologist can administer psychiatric or neuropsychological testing, but for it to be accurate, you need somebody who is actually trained and can determine what these tests mean. While we're talking about treatment, let's talk about telemedicine. By show of hands, how many knew that telemedicine has been an issue in California since 1996? Feel free, put up your hands. Okay, let's go on. From the Telemedicine Development Act of 1996, some medical professionals were allowed to provide telehealth services. And with the Telehealth Advancement Act of 2011, that was expanded to all licensed healthcare professionals. So in California, telehealth is recognized as a valid form of services or of medical services. What this does not say, however, is that the appeals board has not incorporated telehealth treatment into any of their statutes at all. There are no workers' compensation rules and regs. There are no workers' compensation laws saying that treatment must be provided via telemedicine. Now, I will tell you that the board did amend its rules regarding billing to include telehealth as a billable event for treatment, but there are no rules saying that the employee must be served through telehealth. Now, there are rules, and there were emergency regulations originally put in place as section 46.2, then replaced by 46.3, and it is now extended, or there's trying to get a rule through to extend it through January 16, 2013, allowing telehealth medical legal exams. I will say that again. There are rules allowing telehealth medical legal exams, but there are no rules providing for telehealth treatment. So if your applicant is demanding telehealth treatment, you can say no. If they're demanding a telehealth medical legal exam, you can try to say no, but there's some laws you'll see in just a moment that say that yes, they can still get their medical legal exam via telehealth. But I will encourage you, when you're considering whether or not to authorize telehealth treatment, is follow some of the same rules that apply to telehealth medical legal exams. And I'm going to jump to page 25. Right at the top, it says where a QME or AME may complete a medical legal evaluation through telehealth when a hands-on physical examination is not necessary and all the other following conditions are met. This is where they determine that a actual physical examination is not necessary. Now, for treatment, when is that possible? Well, if somebody had a set of stitches or somebody had a surgery and they can direct their camera to the surgery site to show that there's no infection, no inflammation, no bad symptoms, sure, we could follow up with the surgery or stitches via telehealth. But if it's infected, if it's red and swollen, if there are problems, they need to see the doctor. Likewise, if they're on temporary disability, we need the doctor to evaluate their physical capacities and their abilities. So a hands-on physical examination is necessary. And we should deny telehealth treatment where temporary disability is ongoing. So just remember that telemedicine, there are statutes allowing it for medical legal evaluations. There are no statutes providing it for treatment. And if you choose to object to telehealth treatment, you can. You are not required to object to telehealth treatment. And in some cases, it may be valid, but you are not required to do so. By the way, I gave you the full extent of 46.3. You can read through it. It's over the next several pages. And then I give you some telehealth cases. Now, what I want you to note first is that the initial case I give you here with a name I can't pronounce is from 2018, which predates the pandemic and predates this emergency regulation 46.3. But you will see here that in these cases, there were several requests for telehealth that were later rejected. But I'm going to summarize them rather than read through these cases for you. When defendant has tried to stop a telehealth examination before it occurs, the board is loath to stop it. The board will generally allow it to go forward. But when that report issues, the board will oftentimes throw it out for failures to comply with Labor Code Section 4628, which are the medical legal rules that apply to medical legal exams. As you read through these cases, you will see that doctors oftentimes fail to include the names of everyone who participated or fail to advise the parties that the exam would occur through telemedicine. It is those failures which get the report thrown out. So I have recently objected to a telehealth examination. It's a psychiatric examination. I still feel that it needs to go forward in person so that the doctor can better evaluate microexpressions and body habitus during the examination to determine whether the person is telling the truth. But I'm fighting an uphill battle because medical legal exams can occur via telehealth, and the board tells us through case law that we can't deny it without having a specific objection as to why telehealth or why an actual exam would be more appropriate. As you go through these cases, you will find that the Aranhe case, particularly on page 28, allows telehealth treatment for a psychiatric person. And that makes sense. If someone is getting some benefit from their counseling sessions and they can only attend via telehealth, that might be reasonable. But understand, there are no statutes providing for telehealth treatment. Now, I mentioned to you that the Applicant Attorneys Bar, the Applicant Attorneys Association, they actually spend time trying to train people on how to get around the rules. And you'll see I put the heading from one of their presentations as page 30. How attorneys can identify the need for multiple QME specialties. And how many of you have had people ask for a specialty, usually in one we don't even like pain management or chiropractic, and then immediately turn around and ask for another QME in the field of orthopedics or another QME in the field of internal medicine? This is a common problem that we run into over and over and over again. And I will tell you, pick your battles wisely. Now, what am I talking about? If we have denied body parts, if we have denied internal, that creates a contested claim regarding that body part, and it opens the door for a medical legal exam. Now, there is case law saying that any QME can comment on any medical condition within the AMA guides. In other words, a chiropractor can comment upon the effect of a burn or on the effect of high blood pressure if it's addressed within the AMA guides. That is determining impairment. But what it doesn't say, and what the case law doesn't say, is whether that chiropractic QME can determine causation of an internal condition like high blood pressure or diabetes. So if we have denied that medical condition, now we're in the position of having a QME say, well, I'm not qualified to determine whether that is related to the industrial injury. You need a specialist to determine that. So that opens the door for another QME in that specialty. Now, as you know, with QMEs, our best option is to pick first. If we get that option, select the panel of our choosing. If it's an orthopedic injury, select an orthopedic doctor. If it's an internal injury, select an internist. If it's a psychiatric injury, select a psychiatrist. But if we don't get that, can we live with this doctor? Can we live with a chiropractor addressing the orthopedic injuries? Generally speaking, we can. But is it something we need to fight? For example, a surgical back or a surgical knee, is that within a chiropractor's specialty, even to determine impairment? Oftentimes I've deposed chiropractors after the fact, and they will say, oh no, that's outside my specialty. I can't determine impairment for that body part. Now, if I'm being a jerk, I will say, well, doctor, you are a QME and you have studied the AMA guides and you can read, right? So let's turn to the page on high blood pressure and see what it says. But understand, do I want that chiropractor making that decision for me? Now, applicant attorneys will fight QMEs for other reasons. They'll claim that the doctor is not scheduling within the required period of time. They'll claim that they're not scheduling at the address listed on the application. They'll object to reports as not being timely. And you do know that if they object after receiving the report, the objection is not valid. They must object to timeliness of a QME report before it is received. But I encourage you, if they tell you that the doctor isn't scheduling, call the doctor, find out if they're scheduling. On more than one occasion, I have called the doctor, and I've got exams 30, 45 days out, well within the 60 days in the pre-pandemic era and well within the 90 days now. Then I'll call the applicant attorney and I'll say, who in your office called? Because when I call, they're scheduling on this date. And every time the applicant attorney has agreed to go forward with the date that I solicited. Now, if the doctor has changed address, that's a problem we can't deal with. The code allows them to do that for the initial examination, but not for subsequent evaluations. If the applicant has to go to a different address for a subsequent evaluation, that's on them. That's not on us. We don't have to change panels simply because the doctor is not going to that location anymore. Keep that in mind. Understand that just because the applicant attorney is saying something occurred, it didn't necessarily occur. It's a tactic to get us to use doctors more favorable to them, or to get a new panel that may be more favorable to them. Check the information. Let's keep going. Why would we want additional panels? Well, as I mentioned, if the QME requests a different specialty, for example, do you really want the chiropractor commenting on the high blood pressure, whether it's impairment or causation? Do you want that? That may be a reason. We can agree to an additional panel, and if it's necessary, we should do so. And the judge can find good cause for an additional panel. That's us going to trial and offering evidence both for and against that panel. Now, what is good cause? And that also leads me to discuss why we would agree to an additional panel. I have successfully rebutted multiple panels by saying that the applicant never treated or complained about these conditions prior to the QME report, even if they're listed in the application for adjudication of claim. So keep that in mind. If they've never treated for it, never complained about it, even if listed in the application, why would they need a panel in that condition? Which gives me the opposite of that as well, why we might want to agree to an additional panel. If they have treated for that condition, if they have treated for their GERD or their intestinal problems or their high blood pressure during the course of their claim, whether it's an orthopedic injury or not, then we may want to get an additional panel to address that, because we don't want that treating doctor's report to be the only report in evidence. And the fact that they treated with it may be good cause for the judge to award an additional panel. Likewise, us denying that body part is per se good cause for the judge to award an additional panel. So keep that in mind. We may want to agree to an additional panel simply because we don't want the only evidence to be the applicant's treating records, or we know that the judge, once we've denied it, is going to give them a panel anyway. And at least if we agree to it, we can agree to the specialty. So ask yourself, did we deny a body part? That creates a contested claim. Did they treat for this body part? That means we may have evidence of treatment to which we need to rebut. Did they ever report these symptoms to a QME, to any treating doctors? If not, they are likely not entitled to another panel. Now, I give you page after page of QME case law. Look down to the first one on Hernandez, bottom of the page, page 35. There must be a record of testimony or evidence supporting good cause, and that tells us that there must be some information that the judge relies upon to grant that extra panel. It also tells us the judge must develop the record. They should never, ever issue a new panel or ask for an additional panel simply in a minute order. They should determine what that good cause is, and that allows us to appeal it if we don't agree that it's good cause. Otherwise, I'm going to encourage you to read through these cases, as I always do. If you find that the fact pattern meets your fact pattern, then yes, you should read the case and argue these cases in your favor. I'm going to do this for everything except Ponce de Leon on page 37. Ponce de Leon is one of those cases in which the applicant treated for a condition, in this case, fibromyalgia, and he had medical reports regarding fibromyalgia, and the orthopedic QME did not comment on that fibromyalgia at all. Now, the judge ordered a new panel, an additional panel, but that's one we should have agreed to a panel. We do not want that treating doctor's reports regarding fibromyalgia put into evidence without some rebuttal. If applicant is treating for a condition, we want to make sure we have some rebuttal for that condition. Let's move on. I'm going to skip over a few of the cases and go straight to vouchers. Now, if I was standing in front of you right now, I would say, what is the one factor that determines whether an employee is entitled to a supplemental job displacement benefit voucher? Now, a lot of you are probably saying, oh, they have PD, they can't return to work, things like that. Well, the answer is, did we send a notice? Remember how I began this, talking about notices? Well, I'm going to talk more about notices now. What's that notice? That's a notice of offer of regular, modified, or alternative work. If the employee has had any temporary disability, any, once we know that the person is permanent and stationary, whether they're back to work or not, we need to send a notice of regular, that's if they return to their normal job, modified, self-explanatory, or alternative work. Failure to send that notice entitles them to the voucher. I'll say that again. Failure to send notice entitles them to the voucher. Now, we can argue that there was no PD in some cases, and we can argue that the doctor never filled out the proper paperwork, and we can argue that they returned to their regular work, but the statute says we must send notice. Send the notice. Lastly, I'm going to talk about vocational experts because I see more and more of these. All I'm really going to say about vocational experts is treat them like medical legal exams. Is there an issue that needs to be addressed by this vocational expert? Is their report substantial evidence? Is it capable of proving or disproving whatever the contested claim is that brought about this vocational expert? And you will note that the information that a vocational expert must rely upon is nearly identical to the information that must be in a medical legal report. Do they tell you the history? Do they tell you the documents they reviewed? Did they tell you their opinions? And if their opinion is based on a medical basis, in other words, if they're finding vocational limitation based on what the doctor said, did they incorporate the apportionment by the doctors? Did they incorporate the doctor's opinions? If not, the vocational expert's opinion is not valid. So treat vocational expert opinions like medical legal reports, look at them with the same scrutiny, ask what is the contested claim, and then evaluate, does the report resolve that contested claim? With that, I'm going to say thank you and open up the door for questions.
Thank you, guys. Yeah, Jim, we do have a few questions. Let's see if we can hit at least a few. And if not, we can email everyone else. So let me start. What labor code do we refer to for conversion of payments from TD to PD?
The same sections listed in my presentation. There is no specific labor code section or code of regulations allowing for converting benefits. However, you can convert, obviously, permanent disability. If you find out later they're temporarily disabled, you convert that $290 a week and add money to it to make it $1,200 a week if that's what their rate is. Likewise, you can reduce it down.
Awesome. Okay, next question. Can you put a language on Stipe that TD overpayment will be deducted from the award?
Can you put a language into a stipulation
I think
that
that's
TD payments will be deducted from the award? Every settlement we put in, every settlement we enter into, unless we specifically waive permanent disability, we actually list the permanent disability paid and note that we're taking credit for it. You can do that with a credit as well. You'll note on the CNR, there's actually a line for temporary disability overpayment for which we're asserting credit. And if the employee agrees with that, then we can assert that credit. The problem is if they do not agree with that, how do we get that money back? And that's where we have to file the petition. Excuse me, we have to file a petition for credit.
Okay, let's hit another question. Can we send deferrals on non-admitted or denied body parts?
When you say deferrals, I assume what you're saying is deferrals of treatment. And the answer to that is not without asking the doctor how this injury, if it's a non-accepted body part, how it's related. In other words, within 5 days, because we only have 5 days under utilization review to respond, we need to defer the issue and ask the doctor, how is this related to the injury? If the body part is actually denied, technically all we have to say is that the body part is denied. But remember, that opens up the opportunity for medical legal examination, creates a contested claim, and it also opens the door for them to treat with that body part with a non-MPN physician.
Okay, let's see. What is your thought on a psych telemedicine med legal secondary to ortho?
I do not like any telemedicine evaluations. I personally believe that the doctors need to see the applicant. And I will tell you from my own personal experience, I was sitting outside an applicant attorney's office. I saw an applicant walk up go in, come back out, put his arm in a sling, and then walk in again. And during the deposition, he cried as though his arm was in severe pain, which was clearly not evident when he walked in the first time. You don't get that via telemedicine. You also don't know if the person has somebody prompting them to give answers. I've done depositions where I've seen the people turn and look away while I'm questioning them. I don't believe telemedicine is ever an adequate opportunity to evaluate the individual, but unfortunately, we are stuck with it in some cases.
Okay, and let's see. What about UR playing a part in all this?
UR is always vital. UR is important. UR is mandatory unless we authorize the treatment, unless we meet the UR rules, defer the treatment pending further information. Now remember, we have 5 days to decide whether the treatment, once we receive an RFA, is valid or not. Our 5 days to ask for information, and then after that 5 days, we only have 14 days total to deny the treatment. So if we defer initially pending further information, we have to deny it within 14 days, saying the doctor has not provided that information. Now, I will tell you that section 9785, I believe F, gives 20 days for the doctor to respond, but we only have 14. So I usually try and let the doctor know we need the information now, or we're going to have to deny this treatment pending receipt of further information identifying how this body part or this condition is related to this work-related injury.
Awesome, and let's try to just do 2 more, and then if we don't get your question, we will email you back. Does COLA apply to death benefits?
Excellent question. There's case law saying that it does. There's case law saying that it doesn't. I have to defer that question, and I'll maybe I can get your email address and give you the case law going either way.
Awesome, and let's do 1 more question since we're about over 11 a.m. Regarding job displacement voucher, aren't verbal job offers now sufficient, or written offers by the employer not using any of the prior formal forms/letters?
I'm not talking about the job offer itself when I say we need to send a notice. I am talking about the form 10133.5. I apologize, I can't remember the number right now, but there's an actual form that says notice of offer of regular, modified, or alternative work. That is the form we need to send. If a verbal offer was made to the employee, if they have returned to work, send that notice saying that you have been offered and you have actually returned to work. The key is to get that notice out so that we document our file that the offer was made. Remember, a verbal offer is as good as the paper it was written on. And I promise you, if a dispute arises, the employee will say, I never got it.
Well, thank you, Jim, so much for your very animated presentation today. It's lovely to see someone really passionate about what they do, and you can tell that you love what you do. Thank you all for your questions, and just as a reminder, Jim and Logan are always available to answer your questions. You can email me, I'll forward them on, or their information is inside of the handouts today. Just as a reminder, MacroPro is a document retrieval company, and we'd love to get your records, whether it's here in the United States or abroad. We can do that for you. Until next time, everyone, we'll see you later. Bye-bye now.
Bye, thank you.
Thank you, everybody.
Bye-bye.